morning, friends. Today we are going to see foundation of patent law. Indian Patent Act. The Indian Grand Patent is governed by Patent Act 1970 and Rules 1978. The patent granted under the Act are operative in the whole of the India. Before we are entering into the topic, we should just to see history of patent law. When it is started, when it is designed, everything. The patent law of 1856, it was started. The Patent and Design Act 1911. The Patent Act 1970 and the rule is 1972. The Patent Amendment Act 2005 only. The history of patent law in India starts from 1911 when the Indian Patent and Design Act 1911 was enacted. The Patent Act 1970 was again amended by the Patent Act 2005, wherein product patent was extended to all fields of technology, including food, drugs, chemicals, and microorganisms. What is patent? The word patent refers to monopoly right over an invention. Not all inventions are patentable, nor it is essential to protect invention solely through patent. Patent duration. The term every patent in India 20 years. The rate of filling from the application of the patent, irrespective of whether it is filled with provisional or complete specification. That is important. Clear. However, in case of application filled under the Patent Act, like patent and uh, the term of 20 years begins from the international filing date accorded under PCT. What is not patentable in India? It's very important, right? An invention that is frivolous or claims anything obviously contrary to well-established natural law. Natural law against that and all, it's not possible. An invention, the primary or intended use of which would be contrary to law or morality or injurious to public health. These are all not allowed to patentable in India. And invention relating to atomic energy, it's very important. This is also not patentable in India. Is Indian patent valid in US? Indian patent is a legal document that is valid in only the country where the rights were granted. If we are granted rights, so it is valid in particular where it is granted, there it will be valid. So, for example, an Indian patent is valid only in India and US patent is valid only in US. Therefore, you must apply for patent rights in every country where you are interested to protecting their inventions. If you want to protect your invention in some other country, you have to go and do a patent registration over there. Clear? How many patents India's have? According to 2017, India's Patent Office granted 12,387 patents, up substantially from 8,000 to 248 in 2016 and 6,022 in 2015. The worldwide, how much in the sense? 1.4 million patent granted in 2017. Patent laws salient features. Both product and process patent provide. First thing. The term of patent is 20 years. Okay, examination on request. Both pre-grant and post-grant opposition is there. Fast track mechanism for disposal of appeal. Provision for protection of biodiversity and traditional knowledges. Publication of applications after 18 months with the facility for early publications. Substantially reduced timelines. Types of patent. There are three types of patent: an ordinary, a patent of addition, and patent of convention. The second type of classified patent is classified into product patent and process patent. Okay, what is that? What is the cost of patent in India? The cost of filing a patent application in India, individual for one person, 1750 rupees. Okay, for paper filling only. And the request for examination is 4,400. Whereas for online filling is 1,600 and 4,000 for respectively. But the applicant must have digital signature to do that. Without digital signature, they won't be doing in the online application. So just to see the procedure for the grant pattern. First, we have to file the application. Okay, with the professional specification, whatever we are having, the specification we have to complete. Complete specification not filled means it will be moved to other, and it is going to be considered as abundant. Leave it. With the complete specification is over, it is going to request for examination. Otherwise, 18 month of publication it will make move. Okay. If 18 month of publication it will move, after that it requests for examination. And it is moved to first examination report, FER. Then it is moved to reply to FER, refilling of amendment documents. So here, come to this side, 18 publication, 18 months publication is okay. Pre-grant opposition, anything is there, we have to check. Then hearing the pre-grant opposition. Once opposition is acknowledged, it has to be rejected. So the live is going gets over. After come to this side, reply for first examination report it is coming. After that, it has to be moved to re-examination and issue for further objection. Anybody is coming and objecting or not. And it's made to move to objections not completed within a 12 months, it's abandoned. So it's closed. Okay, this is completed. Once it is over, so hearing by the controller. Any problem is there, you have to call, getting a call from the controller. The controller saying whether it's order or decision. Once it is take a decision, patent is going to be grant. Patent is granted means grant for publication. Grant for publication means demand of renewal fees we have to give, and after that renewal fee not paid means it will be patent is cost. Renewal fees paid means patent is continuous till 20 years. That's all. This is the one part. Clear? If it is, I am not saying here the controller refuse, they are rejected. So appeal to IPAB, which will move to intellectual property board. So it is going to be refused, and it is sometimes it is appealed allowed. Okay means here you have to produce. Then again appeal is allowed means patent is going to be granted. Then once the patent is granted, again the process has to be completed. This is the procedure for the grant of patent. Okay, next class we will see the next topic. Thank you.